Hello guys, and welcome to another episode of my lecture. My last episode, where I discussed about rule 6 of a confessional statement, I told you about the fact that the judge must look at the probative value of a confessional statement. And I told you that for us to talk about probative value and all other things, we have to look at rule 6. And that's what we are going to be discussing about today. So let's go straight to my notes. Now, it is established as a matter of law that a conviction can be founded upon an uncorroborated confession of the case as held in EMMANUEL versus the state, and also the case of R versus Abraham ERUMESE. Now, in these two cases, the court also stated that there are certain conditions or certain things that the judge should look out for. Now, the judge should look out for the fact that there is something outside the confession which shows that it may be true. The court should also look out for the fact that the statement contained therein are most likely to be true. The court should also look out for the fact that the accused had the opportunity to have committed this offense. And for the fourth one, the facts stated by the accused are consistent with other facts which has been ascertained and established. Now, in as much as it has been stated that when we are talking about confessional statement is like the most important thing in a particular criminal case. Yes, we know that. But, the goal in a criminal case is for justice to be served. Justice is likely not to be served where that confessional statement becomes inconsistent with other relevant facts in that particular case. Do you understand? When you are talking about a confessional statement must also agree with surrounding circumstances. Where a confessional statement is made and then there is proper evidence before the court that the person was not even in Nigeria the time the offense was committed, how can that confessional statement stand? Do you understand? Although when you are going to raise the defense of alibi, you must make sure that you raise it from the beginning of a criminal trial. You don't raise it. In fact, from the onset of arrest, you must have raised the defense of alibi to give the prosecution and the police the ample time to be able to investigate your alibi. You don't raise it in a criminal proceeding when the trial is on already. Do you understand that? But that is not the case. Now, let us say that, okay, defense of alibi is raised, but the prosecution ignored it. And then the prosecution solely was relying on the confessional statement. Where the court can say that, okay, the confessional statement has been admitted, but also the defense have been able to show that they did not acquiesce in raising their defense of alibi. They raised it from the initial onset of arrest. Not only that, they were also able to show by bringing passports and other travel documents to show that as at the time of that particular offense, there is no way the defense or the defendant would have been in Nigeria. So therefore, you cannot say that confessional statement, even though properly admitted into evidence, will still stand in the face of conflicting evidence of this nature. Do you understand that? Can you see that? There has to be other relevant facts. So when you say that the court must weigh the probative value of a confessional statement, what it means is that we must weigh the truth of that confessional statement, the likelihood of it, happening, that the person must have committed the offense, weigh it in line with other, facts that has been admitted before the court. Note that the court cannot weigh it against facts that is not before it. He has to weigh it against facts that is before it. What if the accused was sick at that time? What if something happened and, do you understand? It's not possible for you to have a confessional statement when it will contradict certain facts. Don't forget, in my last class, I also made a very important point, as has been stated in the case of ERUMESE versus the state. It says that it having been retracted is of no importance. The fact that a confessional statement has been retracted, which means that the person said it and the person later retracted it, is of no importance. The most important thing is that the person said it in the first instance. So the fact that the person said it means that it's going to enter inside evidence. But if the person retracts it and then the person is saying that, oh, he did not commit the offense, then if it has entered, the court has to look at that particular confessional statement in line with other important things that has been stated in these two cases cited in this class. Do you understand that? So a confessional statement on the face of it, means that the accused is guilty, but that is not the end to it. If there are other facts and other things that would convince a reasonable person, in this case a judge, to believe that it is, in contradiction with those other facts, and those other facts are also very relevant, and also is likely to prove the innocence of the accused, then it is very likely that the confessional statement would be struck out, or it wouldn't be upon which the particular judgment will be given against the accused. So with that, I go to my next and final rule on the nature of a confessional statement, which is the rule 7. And after that rule 7, we then go to requirements of a valid confessional statement.